because they certainly have certain sovereignty protections, correct?
We try to make it more often than not. It varies. Sometimes it's more often, sometimes it's not, but right now it's more often.
But they enjoy certain sovereign immunity protections that are based in statute, and not unlimited, obviously.
I couldn't enumerate them, but I'm sure they do.
And similarly, if you had a concern about something, air traffic, commercial air traffic, if you didn't like the direction that a flight was coming into Logan, the state has pretty limited ability to say, we want that plane to land at 2:30, not 2:45. It's bothering us.
My department has nothing to do with air transportation, so I have no knowledge about that.
I guess the point is, I'm not trying to be cute, but there's a whole zone of activities that Congress, in its wisdom, has decided is so important that, and for other reasons, that they should be regulated primarily at the federal level. And rightly or wrongly, because I wasn't in Congress when these laws were enacted, they're on the books, and we need to deal with them. Courts will interpret them. This case may well be appealed one way or the other, and we've got to be real careful the way when we handle it that we not just waste taxpayer money and time by just walking into a loser appeal situation, and we are trying to figure out a way through this thicket.
That's certainly fair. There are a lot of competing forces here.
Now, you mentioned that Massachusetts has not yet received an actual application from NET, and of course, I'm sure their supposition would be if they're preempted or protected by preemption, then an application in a traditional sense wouldn't necessarily be forthcoming. But isn't that, I guess, the point I wanted to explore is we are pretty early in the process, right? I know when I ask our staff here, what exactly is going to go on at this proposed facility? Well, they point me to the record. I've gone through the record. There's a lot of information in the record. As you point out, the record's changed. The plans have evolved, apparently. But really, what I'm getting to is NEPA and the National Environmental Policy Act. And maybe I'll let Ms. Lamb have an opportunity. And Ms. Lamb, would you describe the National Environmental Policy Act as a light-handed environmental law, or one that has some pretty significant requirements to it, and is probably, as I would describe it, one of the most useful laws for citizens in states and localities to avail themselves when there is a federal action involved that might impact the environment?
Yeah, as I understand NEPA, if it's similar to the Massachusetts equivalent, they don't actually deal with permitting issues. They're looking at a facility or a site, and they take a look at all the environmental issues that they would want to raise up, all the environmental issues that's involved in that project, and then they look at each one and see how that would affect the proposed activities will affect the environment there. But it doesn't say, in Massachusetts anyways, I think it's equivalent and similar to NEPA. It doesn't say, they don't look at it in detail, in such a detailed way, and as such as a permitting process, where they say, okay, then this facility can be permitted because they will do this and they will do that. They will only look at just generally if they actually looked at all the environmental issues and try to address them. They don't actually look at whether or not it actually adequately addressed them. So I think I see a difference in just plainly relying on the NEPA analysis or a NEPA review for permitting a solid waste facility. I also wanted to just address briefly your question to Mr. Coleman earlier about sovereign immunity issues dealing with the defensive facilities, and that there are certain areas where the federal government have carved out for them to be regulating, for example, flyovers, aviation. That kind of thing, we're not trying to intrude into the jurisdiction of the board here. We're not trying to regulate transloading. We're not trying to regulate the movement of rail cars. We are trying to regulate processing of solid waste, which is very, very different. And we're not trying to intrude into an area that the board is already regulating. The board, in fact, is not regulating over solid waste and processing facilities. So I think that's one issue I want to point out. And I also wanted to address that there is going to be an environmental gap here, even if you're going to be reviewing this project under NEPA. After you look at all the environmental issues and see if what are the environmental issues involved in the site, you still need to look at for permitting process, whether or not, what type of controls they should have in protecting the public and the environment. I don't believe NEPA does that. I don't believe NEPA process actually say, okay, you need to put in this odor control here, you need to put in this emission control here, and you need to conduct a number of inspections over a number of months so that you ensure that you're not going to create situations like litter or rats. I don't think NEPA can replace this or be a substitute to state regulation under the siting and the permitting requirements. And that's why we're here today.
Well, I know Massachusetts has a lot of experience working in and around NEPA. I will say we also have a lot of experience working in and around NEPA. Major cases such as the D.M.E. Railroad case that went up to the Circuit Court of Appeals, and we were in the end affirmed. We win a lot more than we lose in that area. We've got a good team of expert lawyers and practitioners in that area. I've worked with NEPA in a number of jobs in the past years. A key part of NEPA, of course, is you get the public comment involved. You actually talk about what the federal action is and what environmental consequences might flow from that action. And I guess the reason I describe this is not to give a lecture on NEPA, but to say that we don't know exactly what is proposed for this project right now. It's not actually the point in the procedural the process where we would naturally know every detail. That's not to say we don't need to know those details. We certainly do. Both the states need to know, we need to know, and there's a time for that. It will come through the NEPA process largely. There will be, especially in a case like this, a significant discussion and inclusion of mitigation as part of any NEPA process, assuming we even get there, because of course NEPA could result in a no action or no approval finding before we even get to mitigation. And we will need to find the least environmentally damaging, practicable environmental alternative if we can even approve one. And at that point is when I think I would submit, if we were to assert jurisdiction here, sit down with the parties of interest, the proposer, NET, the state, and talk through, write down the whole list of concerns, what needs to happen, talk about conditions, and then decide whether those conditions are just impossible for this board to oversee, and we need to somehow, under this hypothetical, somehow yield preemption protection altogether and just turn everything over to the state, or retain the preemption jurisdiction and then delegate as much as possible to the state. I heard the proposer say there are about 4 fairly defined areas that they see as largely non-negotiable. You heard the list, the noise because of the overlapping federal requirements, I think there's the pre-certification and the site selection review, and then the recycling issue, which, if I get it right, they view as largely economic regulation in nature and not of any real public health concern, whether they send things to Ohio to get recycled or somewhere else. So I guess I'd say we're at if the challenge to the board is today to reject this application because we don't know everything there is to know about the proposal, that's an impossible standard or level for any reasonable, I think, proposer in the early stages of a project to meet, in my personal view. And I guess I want to talk about the process. There's been statements on the record from multiple parties about attempts to have discussions. Mr. Coleman, you mentioned a return phone call to the lawyer. How was that left? And elaborate for me if you can on your office's openness to actually discussing, which from Mr. Van Tyn's testimony, I heard him say loud and clear, everything is on the table for his client to possibly sign on to and agree to, with the exception possibly of those 4 discrete areas.
Well, I think, as I said earlier, since we're caught in a little bit of a bind there, since we believe that this type of activity should not be preempted, it would be premature of us, I think, to sit down with NET and work about and try and find out a workaround to how we would deal with the issues under preemption scenario. So if the board determined that we were preempted, we would certainly sit down, then we'd know what the rules of the game are, and we'd go forward and try and work out the best way we can. But I think until it's clear to us whether they're in or out, we're a little bit negotiating against ourselves by sitting down with them to figure out how it would work, assuming that they're correct and we're not. So I think that's how we left it.
Okay. Now, the state representative, Representative Maselli was here earlier, mentioned his concern that his constituents, he believes, and he spoke for himself, would not feel comfortable whatsoever and not be supportive or want approval of what I'll call a containerized transload operation with no dumping or sorting or exposure to the air in any open way of municipal solid waste or C&D. Is that the position of the state DEP, that a container to container, taking a container off a truck, putting it onto a rail car and taking it out into interstate commerce, that's unacceptable?
No, in fact, we have, in the Alston case, we had discussions with them. They explained what they were doing, and we determined that we had no jurisdiction because that to us was clearly on the side of being preempted. And if that's what a proponent wants to do at this location, I'm not sure, other than if there were other issues involved, like wetlands or whatever, just general construction things came up, we wouldn't have any jurisdiction at all. So that's not our issue.
One of the things we're wrestling with is, this came up earlier, is just the reality that for many decades, if not over 100 years, items that are put in commerce that are basically, lawful items, which I guess would include, generally speaking, MSW and C&D, but also lumber, bricks, just name the whole list, very often get dumped out of the truck onto the ground, maybe lay in storage for a day or two until the train comes, and then get picked up in some fashion or another and put onto a rail car and taken away. And I'm not aware of any case anywhere that's actually found that any of those activities are not integral to rail transportation. And so it's a struggle. So the question, I guess, that's being put to us, and I don't want to put words in your mouth, but it sounds to be is, that might be true, but we need to find, this board needs to find today, or coming out of today's hearing, an exception to that long-standing practice for MSW and CD, and only MSW and CD, and that it's a discrete and defined activity that would be reasonable to just segregate out, and that the statute allows us to do that. Is that, I don't want to state your view for you. Does anybody want to let anybody in the panel jump in on that?
Oh, Mr. Chairman, I'm sorry, go ahead.
No. I would like to say that we're not asking the board to create an exception out of this, what other railroad facilities typically do. I think when, as proposed here, and then I think we have enough information for the board to make a determination. They essentially process the waste. They don't just put it on they dump it onto, they don't just transload, they dump it onto the ground, they manipulate it, they sort it, and they actually segregate materials and they shred it. They change the consistency, they change the waste stream into processed waste versus unprocessed waste versus material that could be recycled, and all of these material needs to be handled differently. So in our view, we're not asking you to create a new exemption or a new exception for solid waste here, but to just look at the facts of this case to say, to make a ruling on whether or not the processing activities.
I'm not an expert on the operations of any of these transload facilities, but we've heard a lot about it today, and maybe by the end of the day I'll be almost an expert. But let's just talk through this, because it doesn't sound that complicated. Truck pulls into a building, dumps a bunch of miscellaneous construction and demolition debris, onto a concrete floor and it sits there for 12 hours. Somebody comes by with some type of a piece of equipment, maybe looks like kind of like that red piece of Daewoo equipment in the picture there, and picks up the material and deposits it in a rail car for transportation. Nothing else is done to the material. Is that waste processing in your view?
Under Massachusetts regulation, it is waste processing.
Just surely the depositing onto the ground is processing, or is it the picking up, or is it the fact that it? Help me understand, why is that processing?
It's a handling facility. In Massachusetts, when you handle waste, the regulations governs how you handle the waste. When it creates dust. So, when we regulate, we want to make sure that it doesn't create too much dust. So when an activity creates that kind of condition, nuisance condition, it falls within Massachusetts regulations.
And so if the next thing the proposer wanted to do was to, once the material is deposited on the ground, to immediately wrap it in some type of plastic coating in order to both make it easier to move, but also to protect it from blowing out or falling out of a rail car, to basically contain it for transportation, adding no value to the material. Is that processing in your view? And that could include baling, I guess, or some type of that we're wrapping.
Yes, I mean, if it's baling the municipal solid waste, we argue that it is part of processing. First, they don't need to do that in transloading. They can just dump it into the rail cars. There's no need for baling. And I guess the example you gave really depends on how they do it. If they're going to wrap it, if they dump into rail, if they transload the material from the truck to the rail cars and then covers it up, which is controlling the dust, that sort of goes part of your example. I think that would be transloading. But if they manipulate it in certain ways, I believe that would be processing.
If I hear you correctly, Ms. Lam, you have kind of almost a necessity test. In other words, if you go to a rail transload facility or rail yard, there are probably a number of ways different commodities can be moved. They can be moved like, one piece of wood at a time, or bundled up. It's obviously, railroads are interested in economies of scale and bundling up commodities and making sure that they can put the most material possible into a car and then taking it out. Seems to make sense from a business proposition. If I hear you correctly, since it's not per se scientifically, required to bundle or bale, because everything could just be dropped somehow. Although it can't be dropped on the ground, if I heard you correctly, but it could be potentially a claw could come down. Let me ask you this: if the situation was the piece of equipment, that red Daewoo equipment in the picture there, reached into the truck cargo container, plucked out without dropping a single piece of paper or anything else, a bunch of MSW or C&D, and put it into a train car without dropping a thing, is that processing?
No, that is not processing.
That's not processing because it wasn't disturbed or touched, or how's that different from being placed on the ground for a little while and then put in?
I guess when you put it on the ground, it creates a lot of nuisance issues, pollution issues. And one other thing I think Mr. Monroe mentioned, that this is as a policy matter. You need to consider the nature of solid waste in this analysis, and it creates such a nuisance condition that is traditionally regulated by the states. That is one of the factors you need to look at. In terms of, going back to the example of just leaving it there, I think if the board conditions, if you authorize this project, put some conditions on how long they can leave it there, and controlling nuisance issues, I think our position is that as long as they don't do any kind of processing and manipulating it and sorting it and grinding it and shredding it, that we would concede that it would be constitute transloading.
I'm sorry, could you repeat that? What would constitute transportation or inherent to transportation?
If they do not process in such a way that they manipulate it, grind it, segregate it, sort it, or even bale it, I would think that they would, as long as they're just doing it for temporary storage and then moving it onto the rail cars, I think we can grant that that is actually transloading.
Okay, so if it's temporarily stored, if it's put on the ground and temporarily stored and then picked up, and I'll ask that for the third time because I'm getting some different answers here.
Well, I mean, we're really parsing through, obviously, what...
That's what it's all about, though, right? I mean,
process
this is a rubber meeting the road here.
I understand,
and
and exactly where the line falls is difficult. I think I might give a slightly different emphasis. I think in Massachusetts, we have transfer stations and we have processing stations. Transfer stations bring in the waste. They don't do anything to it. They move it from one container to another container. It generally is consolidation, which is what's suggested here, and it moves usually by truck. I think we would probably make a distinction between transfer and processing on a case-by-case basis. Exactly where that line would draw would be a little bit. I wouldn't want to do I wouldn't want to necessarily do that in the abstract. I mean. But clearly there's a line there somewhere, and if it were what I would call transferring, we would probably concede that is not processing. We would concede that's not processing. There is a difference. I don't know if this is helping you or confusing you more. But,
well, it's helping me because I think it gives me a little more full appreciation of what it must be like to actually make an application, frankly, before you. I mean, this would be very frustrating if I were a legitimate, honest business person. These would be the questions I would have, right? Trying to follow the law. If I want to put this lawful material that for hundreds of years has been laid on the ground for a period of time and picked up and put on, and all, is that transportation or is that processing? And I'm getting multiple answers from two people on the same team, and that's what this case is really all about, right? I mean, this is what you aren't surprised to get these questions, are you?
No, I think that someone coming to us and applying for a permit, there's generally not much confusion about what they're doing. It's pretty much the same permit. I think in this context, by getting into this, and rightfully so, getting into such parsing so carefully through the difference between transferring and processing, we raise all these questions out in the real world with real people putting up these facilities. It really doesn't come up that much. We don't have a lot of, other than in this context, a lot of discussion or disagreement about whether someone's a transfer station or a processing station.
If you assume, let's just work with me here, assume that it's no longer in a real disagreement, that in a hypothetical case, we're talking about a rail carrier. Let's just put that part of this controversy to the side for the time being. So we're talking about a universally agreed, recognized rail carrier. And do you recognize that federal law treats legitimate rail carriers quite differently than rank and file businesses out in the community that are not rail carriers?
Yes, absolutely.
And that doesn't all just emanate from things this board's made up. That's mostly Lincoln statute, case law. Okay. Because I'm going to ask you a few questions here, and I think you'll see hopefully the logic of why I would ask. Because a lot of activities happen at rail yards that are relevant to rail transportation. It's not just trains moving through in sealed containers. These are like industrial parks unto themselves. Let me give you an example. I imagine out in the economy, the general non-rail economy of Massachusetts, Mr. Coleman, the DEP keeps an eye on, or maybe a sister agency, on something such a business such as a fuel yard. If somebody had a bunch of fuel tanks and was regularly filling up vehicles with diesel fuel and had a lot of fuel lying around in storage and stuff, that's something that's probably regulated to some degree, isn't it, at the state level?
Correct.
Okay. Large engine repair facilities where battery acid is potentially exposed, oils, fluids, coolants, would large commercial engine repair and service facilities be regulated by your agency or another agency?
By my agency, only to the extent that they are a generator of hazardous waste. We would not, or air emissions. We would not otherwise regulate them as just an industrial activity.
Partially regulated, I guess, maybe.
Well, to the extent they have air emissions that are subject, or to the extent that they are a small or large quantity hazardous waste generator, we would regulate them.
If a non-railroad business wanted to store a chlorine tanker container somewhere, would somebody in the state of Massachusetts governmental regime have something to say about that off railroad property? Let's say it was a water plant that used chlorine for legitimate purposes, but do you have storage and handling requirements for things like chlorine gas, chlorine?
I'm not aware that we do. We don't at Mass DEP. We don't.
Nuclear waste, if something came down from New Hampshire or something and was stopped at a private non-rail facility in a truck or something, some state level of environmental concern or regulation?
I don't think so.
I'm surprised to hear that, actually.
Anyway, not by us. I can't speak for other agencies.
I ask these questions not to be cute or difficult. It's just there are a whole gamut of long-standing, I would say controversial for sure, troubling in many respects to many people, but actually in protected and legitimate activities when done in the course of rail transportation. And it doesn't mean states shouldn't be concerned about them. You absolutely should, and you are. And there's other venues and other controversies in this town and bills and things where these discussions are being had. But I just I point this out because let's say we get this case just right, and all the parties go away happy somehow miraculously, state especially. Then we have the next case, and it's not municipal solid waste, but it's something else that's being moved in rail transportation that the state's got a legitimate reason to not be happy about. Where do we go? Does this board really have the ability, the discretion to just pick and choose which ones we think Congress meant not to include when they said, and I'll quote from the Ninth Circuit, a circuit certainly not known for its insensitivity to the environment, City of Auburn case not too long ago, 1998. We find that the plain language of the two sections of the ICTA, Interstate Commerce Commission Termination Act, explicitly grant the STB exclusive authority over railway projects. Section 10501 of the ICTA, which governs the STB's jurisdiction, states the board will have exclusive jurisdiction over the, quote, construction, acquisition, operation, abandonment, or discontinuance of spur, industrial, team, switching, or side tracks or facilities, even if the tracks are located or intended to be located entirely in one state. The same section states that the remedies provided under this part with respect to regulation of rail transportation are exclusive and preempt the remedies provided under federal or state law. The section unambiguously states the authority of the board under this subchapter is exclusive. The case goes on to say there's nothing in the ICTA that shows that Congress intended to only to preempt economic regulation on a significant case, but this is what we're struggling with. I'll invite any of the witnesses here to try to help me sort this out.
Well, Mr. Chairman, I'd like to comment on that because I think it was in the Auburn case, in the board proceeding in the Auburn case, where I think it was the board, and I could be confused on the case, but I know the board has said that, for instance, whereas states have no ability to permit or to require approvals on rail construction projects, that's within the exclusive jurisdiction of the board, the states do have authority to penalize and fine or otherwise stop railroads from, for instance, I think in the Auburn decision said that they were dumping things into a waterway. Okay? That's a distinction which I think is relevant to the solid waste situation. From our perspective, it's not a question of whether it's rail transportation or not so much as it's a question of municipal solid waste and C&D waste and other kinds of waste are dangerous commodity. And at least in New Jersey does not claim that it has the power to say you cannot have a solid waste transload station here, or you cannot have one at all. It doesn't take that position. Quite the contrary. It enacted its 2D regulations, which said, when you do this, just do it safely. And so it doesn't really matter whether it's where you draw the line on transportation, whether it's, whether you dump it on the ground or you don't dump it on the ground. So long as you do it safely, there shouldn't be a problem. And with respect to...
Can I just jump in? I'll let you finish.
Sure.
Just while you're on that thought. So in New Jersey, it might be allowable to bring in by truckload C&D or MSW material, deposit on the floor of a building, and then pick it up and put it onto a rail car to be delivered. It might be allowable if it's done safely, in your view.
Well, it is allowable.
Okay.
That's what the 2D regulations say. The 2D regulations say, if you want to have a transload station where you're handling solid waste, you have to follow the same substantive standards that everybody else does. Make sure it doesn't pollute the air. Have an air pollution system. Make sure that if there's storm runoff or waste runoff water, it doesn't run off the pad and into the soil or into the nearby streams. It's not. Make sure you have a fire suppressant system.
Well,
make sure that your building meets building codes.
Let's continue with just the typical transactions that we're talking about, because there aren't that many earlier today when we were hearing from the proposer what types of activities they have in mind potentially. It was the depositing on the ground and picking up. I heard baling. I heard potentially wrapping. Are those things unto themselves, baling and wrapping? Does that amount of processing in your mind that takes this out of the ambit of transportation and puts it in the ambit of processing?
I think we think it probably does, but in New Jersey it doesn't make any difference, because if your facility, if you're a rail carrier, a recognized rail carrier, and your facility is a safe facility and it meets the very fundamental, and these are minimum requirements. These are not special requirements. They're the minimum requirements for handling solid waste, so that you don't pollute the environment, you don't pollute your employees or the surrounding neighborhood, and they're applicable to everybody else. If you do that, then you're fine. New Jersey does not have an agenda, as it was suggested earlier, or a vendetta against rail transfer stations or rail transload stations. Quite the contrary. Everybody, I think, sitting at this table, and probably anybody who has a brain, realizes that transporting solid waste by rail is a lot better than having 5 times as many trucks on the road. And New Jersey does not want those trucks on the road. All New Jersey wants is for railroads, if they want to be in this business, if they want to transload, to create a transload, just do it safely.
We have a number of people presumably following this proceeding, both here in the room that I can see, and also over the webcast. If a law-abiding, well-intentioned business person thinking about getting involved with rail transportation or adding a line of business transportation we're listening today, do you think that person should come away feeling that Massachusetts and New Jersey are completely on the same page with how they would answer a question such as the one that I posed about depositing C&D material on the ground temporarily and then picking up and putting it? Is that processing or not? Because I heard a different answer from you, and of course states have a right to have a different answer.
Well,
you're speaking for your state. I respect that. I want to understand, though, it doesn't seem to be a one-size-fits-all approach that each state is comfortable accepting on this.
I really don't know what Massachusetts law is, and I can't speak for them.
Well, we have the Attorney General here. She gave us a pretty clear, well, I don't know if it's clear, but she gave us several responses to the very same question.
But I guess what I would say to Mr. Chairman, that in New Jersey has dealt with the situation in an entirely different way. New Jersey looked at the board's precedents with respect to preemption and said, look, we understand that our normal permitting and pre-authorization requirements are not going to apply to railroads. They're going to be preempted. And so rather than worrying about that, they crafted a set of regulations which apply to substantive standards and meets what we understood to be the board's very established precedent, that so long as it doesn't require pre-approval, so long as it's a health and safety regulation pursuant to police power, so long as it's not discriminating against railroads or interstate commerce, and so long as it's not interfering with rail transportation, it's not preempted. And there's no reason why, from our perspective, there's no reason why it should be. It doesn't really matter in New Jersey where you draw the line in terms of whether it's processing or not. If you're doing it safely, it doesn't matter.
Okay, I do want to get to my colleagues. I appreciate their bearing with me. This is my last question. To Massachusetts, Mr. Coleman, I heard reference to a requirement in Massachusetts for sorting for recycling material. How does that work? In other words, if a truckload of MSW pulled up to an otherwise lawful facility, but had some recycling material in there, and the operator wanted to follow, if I heard that this is correct, the mandate to sort for recycling, how do they do that in the course of transportation without automatically stumbling into the processing trap?
I'm not sure about the processing trap situation, but they come into say a municipal solid waste or C&D processing facility, or a landfill. If that truck has more than a de minimis amount of a banned material, then they have a couple of choices. They can, if it's not completely mixed in, when it gets dumped on the floor, they can separate it out, and they do, and they put it off to the side, and they put it aside for recycling. They can tell that particular hauler that they won't take that load, or if in the practical situation, they let it go and give a report to us, and then we try and get in touch with the generator and encourage the generator to separate the material at the source.
So to follow that mandate, they would have to, practically speaking, probably have to dump this stuff out. It's kind of hard to reach in from the top of the truck and really find it. Dump it out on the ground, make a good faith effort to sort out the recycling, and then scoop the stuff up and put it in the train. If they did it all in lickety-split in a about as sanitary environment as possible, if I follow this land description, though, that's still processing. I hate to use the word trap, but trap is when you get ensnared in something that you didn't see because it's sort of hard to recognize. And based on that, I mean, it almost has the trappings of a trap. I mean, how does one engage in transportation if they want nothing to do with processing? They have no intent to be a processor. They just want to abide by different standards that they've entered into, presumably if we go down the route of conditional approval, if we were to do that, or delegating some authority to the state to help us with this. How do they meet their recycling set-aside requirements and not dump something out and do a little bit of sorting, which Ms. Lamb says instantly gets you into processing? Well,
for example, in the Alston situation, they bring it in sealed containers and it goes off, and we
they don't sort. They don't know if there's any recycling.
It's our job to get back to at some point, it got into a sealed container and was brought to the rail yard. So at some point, at the site of generation or at the site of consolidation, in that case, I don't know where it exactly comes from, either the generator or the hauler is responsible for reducing to the maximum extent possible the sending of recycled materials for disposal.
So if the hauler wanted to, in a good faith manner, abide by that and actually separate out, how could he or she do that without being classified as a processor under Ms. Lamb's?
By working with his customers and before he picks it up and say, okay, I want 3 bins here. I want 1 bin for the MSW. I want 1 bin for the non-cyclable C&Ds, and I want another bin for everything that's recyclable. And now I'll get 3 trips instead of 1, and I'll take it all, and I'll take the recyclables and sell them, and I'll take this other part for disposal. It works very well. We really don't have a problem with it.
Okay. I'll yield. Appreciate the patience of my colleagues.
If I may, Mr.
Ms. Lamb, certainly.
Sorry. I just want to clarify my confusing answer earlier. I just want to make sure that we understand that when I say processing activities, and that's governed by state law, there is several. Solid waste is handled many different ways. There's the transfer of the solid waste, and then the transfer station is also governed under Massachusetts law, and then there's a processing facility that's also governed under Massachusetts law. As proposed, the project is proposing to process. They did not propose it in such a way they will just dump it, store it, and then package it, and then ship it off. That is not the project that we're looking at. I mean, if we're to look at another project of where they just put it temporarily, store it, and perhaps if they temporarily store it and then put it on, load onto rail cars, yes, you may say that we may not have jurisdiction. But going back to what Mr. Monroe said, is that even if we don't have jurisdiction, we still have, they just have to comply with the public health and safety regulations. They still have to comply with the law. So I just want to clarify, when I said processing, when they dump it into floors and then start manipulating it, that's processing. It is not integrally related to rail transportation. That's where we say our law should not be preempted. If you change the scenario, if they are changing their project today and telling you that they won't be doing any of that stuff and they're only dumping onto the ground and then putting onto the rail cars, we may be preempted. You may rule that we are preempted, but we are still saying that they should comply with public health and safety regulations.
So now it's your statement that taking it out of a truck container, putting it on the ground, and then placing it onto a rail car could very well be protected under the preemption doctrine as integrally related to transportation.
That's correct.
Okay.
It could very well be, but and I second what Mr. Monroe said, they should still be doing it safely.
And this is important. These aren't just intellectual or trick questions I'm asking. We might, in this case or another case, have to seriously look at conditional approval. And so that's why these questions are so important, because if we think we're conditionally approving something and then you come back and say, well, actually I meant that it's not transportation, that's processing too, we're sort of back in a never-ending circular dispute here. Mr. Coleman?
I just want to, just for the sake of illustrating what Ms. Lamb is saying, I think gets to your point. In Massachusetts, as I said, we have 11 permitted C&D processing facilities where they process the material. We have 3 under permitting. We have 203 municipal and commercial transfer stations where all they do is they transfer the waste from smaller vehicles to larger vehicles. I think where Ms. Lamb is going, where I would be going, is that the transfer station scenario is much closer in our minds to something that would be preempted by you than the processing scenario would be. I think we're a little taken aback by the proposal, by the material that came in this morning, because that's not how we had understood it, what the proposal was. And it seems like NET has been, over the last several years, shrinking its processing, what we would term processing, smaller and smaller in order to deal with this preemption issue, which is fine. So I think we were clearly trying to dance around that, but I think it's a little clearer now.
Thank you. Vice Chairman Buttrey? Mr. Mulvey?
Just very, very briefly, we appreciate your patience. And is New Jersey the only state to promulgate the special type or category of solid waste regulations, your so-called 2D regulations? And if other states have as well, have they been challenged in the courts?
To my knowledge, I think this was in our statement of position that we filed on Monday, I believe Vermont and Ohio, do I have that right? I think Vermont and Ohio have similar, and I haven't looked at them, so I don't know if they're exactly the same, but similar types of programs for making accommodations for rail preemption, but still requiring compliance with basic health and safety standards. I think there are also similar types of local requirements, I think, in New York City and perhaps in Westchester County as well. Whether they're exactly like the New Jersey model, I can't tell you, but I think that there have been other attempts by. I'm sorry. I was thinking of another program, which is the A901 program, which I think we mentioned in our papers, which goes to background checks for people who are involved in the solid waste industry, based upon a long history of infiltration by organized crime. But in terms of the 2D, no, I don't know that there has been any other state or other programs that are similar to that.
One final question for the panel from me, and that is, what is your budgets for the two DEP departments for inspecting and solid waste facilities? And in case of Massachusetts, what is the fee that you charge? How much is that fee? And
I don't have that number with me. I don't know.
no,
And I do not know.
Maybe someone from the Massachusetts industry, maybe on a later panel, could tell you what the fee is. I just don't remember what all the fees are.
okay. Thank you very much.
Any additional questions for this panel? Thank you, Pat. You've been very patient. This is a critical panel. You're on the front lines looking after the environmental and safety protections for your people. We appreciate the work you do, your service, your dedication to public service, and we will dismiss you now. Have a safe trip home. You're welcome to stay as long as you want to.
Thank you very much.
Next panel will be panel 4, Mr. Stephen Richmond from the Coalition Parties, Mr. Stephen Changaris of the National Solid Waste Management Association, Ms. Dana Huff of the Solid Waste Association of North America, Mr. David Bayer of the Massachusetts Municipal Association, Mr. Scott Peterson of the Integrated Waste Services Association, and Mr. Michael Camara of the New Bedford Waste Services LLC. Welcome. You have a combined total of 30 minutes, and we will start with Mr. Richmond.
Thank you, Mr. Chairman. Let me start by saying that we have abbreviated our panel participants, so there'll just be 2 of us today.
Well, and all the statements will, of course, be kept in part of the records, and it will be considered.
Thank you. Thank you. And I also want to say that we eagerly await your questions. Chairman Nottingham, members of this board, thank you for the opportunity to speak before you today. This is a very important debate, and we really appreciate the attention and the focus that you brought to this hearing. My name is Stephen Richmond. I'm with Beverage and Diamond. This is Mike Camara, who's with New Bedford Waste Services here with me. And it's an honor for us to be able to speak to you on behalf of a number of organizations and entities. And those entities are the National Solid Waste Management Association, the Solid Waste Association of North America, the Massachusetts Municipal Association, the Integrated Waste Services Association, the Construction Materials Recycling Association, and New Bedford Waste Services. We speak to you today on behalf of solid waste companies, solid waste facility owners and operators, both government and private sector, and most of the municipalities in the Commonwealth of Massachusetts. It is unusual for industry and government to speak with one voice on the subject of regulatory authority. But on this issue, we have strong agreement. There is a business that conducts solid waste management, and there are government regulators who regulate that business, and that business and those regulatory activities are not a transload operation. The rail industry has great importance in America, and that value is clearly recognized by all of the folks who we speak for today. We do not seek to create any barriers for transloading operations, nor do we seek to cause any problems for the rail industry. We have reviewed the comments submitted recently by Norfolk Southern, CSX, and the Association of American Railroads, and I think there is common ground here. The board can issue guidance under the facts of this case related to proposed C&D and MSW processing, and I think even New York Susquehanna has agreed in its comments that board guidance would be helpful in this area. We do not want a ruling that generically addresses all transloading activities. We simply want to ensure that the business of solid waste management is recognized as a separate business from rail transportation, so that waste management continues to be subject to state and local law. We think you can make this determination within the confines of your past decisions on the reach of the board's exclusive jurisdiction under ICTA. From the government perspective, solid waste is potentially dangerous and must be regulated to protect public health, safety, and the environment, as you've heard from the past panel. State and local governments regulate solid waste because improperly run facilities can cause serious problems, and you've heard some of those problems from past speakers today. Rats, insects, disease vectors, air and water pollution, odors, other nuisance conditions. These are serious concerns. Ensuring the safe management of solid waste is a classic government function, And simply put, we think if you strip local government of its jurisdiction in this area, you put the American public at risk. From the private sector perspective, solid waste management is a business. Companies use heavily regulated facilities to transform the value of mixed waste streams. They have developed a special expertise in managing difficult materials, and they perform admirably. These activities are completely separate, we believe, from the business of transloading and transporting wastes. From both the government and industry perspectives, this case presents the same glaring problem. We believe NET is trying to blur the lines of distinction between the highly regulated waste business and the deregulated rail business. We think NET is attempting to vertically integrate these two activities. Why? You've heard some of that today, and we will provide you more information on this. Waste management is expensive, and that's due to the cost of regulatory programs. If you strip out these programs, you save a lot of money. There's no question about that. You can undercut legitimate solid waste operators by offering your service for a lot less. You don't need to do this to ship waste by rail, and that's evidenced by the large intermodal waste transfer facility that you've heard about in Boston. And there are several others that Mr. Coleman mentioned that exist in Massachusetts. We have no problem with those operations. We think the board would agree that ICTA was not intended to deregulate the solid waste industry. To do so would undermine public health, safety, and the environment, and would profoundly change the relationship between communities and the rail carriers in every state where waste management is heavily regulated. And it would threaten the many billions of dollars of investments that legitimate companies have made in creating a protective infrastructure. There's really no delicate way to say this. We think there's a serious credibility gap in this case. The facts do not seem to fit, and they keep changing. NET has previously described several activities that it intends to perform that we know to be waste processing, and we know to be value creation activities, and not transportation activities. We heard a whole bunch of new information today from Mr. Van Tine, and those things included NET will only pick out large pieces of metal and wood. NET will only temporarily set aside these materials, and then we'll send them to a landfill. NET will only shred to a 2-foot specification and not smaller, which incidentally is probably consistent with the requirements of landfills in Ohio, which would reject material that's less than 2 feet in length. And NET will be loading these materials into the same rail car, I heard Mr. Van Tine say, shredded material on the bottom, larger pieces on the top. In today's submittal, we also heard that large pieces of metal and wood would be set aside temporarily and then loaded separately into the rail cars going to the landfill. Prior statements have been inconsistent. To begin with, the letter that NET submitted into the record just a week ago, and which it had submitted previously from NET's lawyer to the Massachusetts DEP, October 14, 2005, said NET will segregate certain metal and wood or other materials which may damage NET's loading equipment in rail cars. Any segregated material will be transported to an appropriate receiving facility or returned to the shipper. This is not consistent with what they said today. In the statement, the verified statement by Robert Jones, dated November 30th, 2005, NET said, all of the C&D and MSW consigned to NET will be shipped to landfills or processing facilities outside of Massachusetts. He also said in that same statement, NET will inspect all cargoes received for shipment. Non-conforming materials will be removed from shipments and will be disposed of appropriately, either by returning them to the shipper, disposing of small items as waste, or as unclaimed freight. This project keeps evolving, and as we just heard from the last panel, we're in agreement with the statement that it seems to evolve in order to try to reduce the likelihood that there would be an adverse ruling in this very proceeding. That's a problem, because that same problem led to the dismissal of the previous NET petition, when the project changed so much that there was no basis that the board found to continue. We think NET's activities will create marketable products, some that are extremely valuable. we think that they will create segregated streams of waste materials that have a different value than the mixed streams which arrived at their facility. These activities, we feel, do not fall within the statutory definition of transportation. What we're asking this board to do is to make a decision, which we think could be consistent with your past decisions, that clarifies when NET's handling of waste would be integrally related and when those activities would not be. This issue cries out for clarity. Merely adjusting requirements to be recognized as a rail carrier, while helpful, will not do it. In other words, if you simply focus on the question of what constitutes a rail carrier, as some parties to this proceeding have suggested, that may solve some of the problem, but that won't provide the guidance that we think is so critically needed about what constitutes an integral relationship in this particular business. We want the board to determine that waste extraction, segregation, shredding, and baling activities, as proposed by NET, are separate solid waste business activities and do not constitute transportation under ICTA. What I'd like to do next is to turn to some of the issues that were raised by the board in its March 29th notice. The board had asked whether it's premature to issue a preliminary decision given the pending Third Circuit appeal and the ongoing EPA RIFS process. And we're pleased to report on this issue, at least this very first issue, we're in complete agreement with NET. We think there are compelling reasons why the board should not delay its decision. Those are in our written statement. I don't think I need to repeat them here. But importantly, we urge the board not just to act, but to issue a final decision on this jurisdictional issue. We believe it serves all the parties to this proceeding if there's a binding interpretation. And if there is going to be an appeal by any party, that should not be delayed by your issuing a preliminary decision. The board has also asked if NET's waste activities are determined not to be part of rail transportation, what impact would this have on the NET proposal and on the transloading of other commodities by railroad? As Mr. Camara will discuss in a minute, the board need not treat waste any differently from other commodities. A determination that NET's waste activities are not rail transportation should therefore have no impact on other transload operations. In each case that's presented to this board, activities should be evaluated under the board's integral relationship test. Where rail carrier activities are necessary for rail operations, they constitute transportation under ICTA. If, for example, coal is staged and sampled and weighed as an integral part of a rail shipment, or if a product is quality tested during transloading for purposes integral to the rail shipment, or if a product is heated to allow for the transfer in shipment, those activities are going to constitute transportation under ICTA. I don't think those are difficult decisions. The board has also asked, in determining whether a facility is a rail transload, must its activities be solely transportation activities, and may a determination be based on the type of commodity involved? Does it matter that the proposed facility would handle multiple commodities? The labeling of a facility should not determine its status. Commissioner Mulvey's suggestion that you could bifurcate this issue, I think, is a very sound one. It's the activities and who conducts the activities at a facility that are critical. The board has previously determined that you can reach different conclusions about separate activities at a single facility, essentially the bifurcation concept. In the town of Milford, for instance, this board found that a rail carrier was conducting transportation when it delivered rail cars into a facility built across a track. But then the company that unloaded those rail cars and then fabricated steel structures in the same facility was not conducting transportation. A facility can therefore be subject to different statutory obligations when different activities occur, and activities that constitute transportation by rail are entitled to ICTA preemption. Activities at the same facility that don't are not so entitled. The board has also asked, in determining whether NET's proposed activities would be part of rail transportation, would it be enough that an activity facilitates transportation, or must that activity be essential to transportation? I think most of the commenters to this hearing, not all but most, have agreed, as we do, that this board has repeatedly used and should continue to use the integral relationship test, and that would determine whether an activity constitutes transportation. The test, as you know, appears in numerous board decisions and has been adopted by many federal courts. As this board said in High Tech, to come within the preemptive scope of 10501B, activities must be integrally related to the railroad's ability to provide rail transportation services. It is therefore simply not enough, in our view, that an activity merely facilitates transportation. Such a test opens the door to abuse, and we would argue that that is the exact door we're looking through today. Many manufacturing activities could be said to facilitate transportation, but would not be integrally related to providing rail service. As examples, consider sawmills, slaughterhouses, sand and gravel operations, any other business that produces products that are easier to ship than the raw feedstocks that they first receive. NET's waste processing is not integrally related to proposed transport services. The extraction of metals and woods, the shredding of waste, is economically motivated, and we will speak to that in just a moment, and would be performed for separate business reasons. Even if some incidental benefit for rail transport is conferred, these activities do not pass the integral relationship test. I would like at this point to turn the microphone over to Mr. Camara for a discussion of the board's questions regarding whether C&D and MSW should be considered differently from other commodities and whether NET's processing would add value to incoming materials.
Thank you, Steve. Mr. Chairman, members of the board, thank you for providing this opportunity for me to speak with you today. My name is Michael Camara. I'm the president of the Medford Waste Services and vice president of ABC Disposal. I'm also the chairman of the Massachusetts chapter of the National Solid Waste Management Association.